Hi there. Another day in the life of a small business employment attorney video. This one's going to deal with three, in my mind, very classic scenarios, right? Very common in my practice, all from client calls today, this morning. These clients are on our monthly flat rate program. It's an unlimited advice program, so this gives you a good idea as well what it would be like, working with my firm to get a preventive legal advice to avoid employee lawsuits in the first place, right? So scenario number one, client calls me up, long time monthly flat rate client, is the whole time very concerned about getting sued, rightfully so, in the sunny state of California. And basically calls me today and says, hey, you know what, Scott, I have this long-term employee, female. She's been getting regular raises over a period of time. And as he put it, she's kind of sneaked herself up to $75,000 a year. And he doesn't feel like, and his partners don't feel like they're getting appropriate value for that $75,000 price tag. He tells me he could probably get somebody to replace this person at $40,000 for what they're doing. Okay, so, love this client. We've been together a long time. But I told him, look, hey, what's on the radar for me is a potential age discrimination case, right? Believe it or not. So I asked him questions like, well, how long has she been employed? About 10 years, looks like. How old is she? His first answer was, well, she was over 40 when we hired her. See, he learns, he knows, the protected category for age discrimination is anybody that's 40 years of age or older. And so he tells me that first. I go, but how old is she now? And he goes, 50. So I said, well, she was in a protected category when you hired her, but she's even more protected now. She's older, right? 10 years older. She's in her 50s. So I told him, he asked me, what do we do? How do I go about this? I don't want to, I need to fix this, but I don't want to buy a lawsuit kind of thing, And he said some recent challenges, potential litigation stuff come up recently as well. So it's particularly acute for him at the moment, avoiding lawsuits. Well, it should be at all times, right, for a California employer. And so basically I told him, here's what to do. Because, it's classic, right? We have an employee, kept them along for a decade, kept giving them raises. Oh, by the way, the employee thinks she walks on water, right, when we don't agree, okay? So I told him, look, we kind of have to bend over backwards and treat this person with kid gloves for the quote setup, as I would call it, right? We're not going to just fire her, obviously, right out of the box. She has an obvious age discrimination claim. We kept her this long. Why are we firing her now, kind of thing? And so I told him this is going to be a process. First process is we're just going to sit her down and recalibrate expectations, I call it. Friendly, non-confrontational, verbal meeting, where we kind of just let her know the truth from our perspective that, look, hey, she's getting paid $75,000 a year. We don't think she's producing enough work quantity issue and then also quality issue. Very, very friendly, just matter of fact, letting her know, what our expectations are and what needs to change going forward. I told him if there's pushback, we need to deal with the pushback, because ultimately we need to figure out if we can get this person's buy-in, right, for our recalibrated expectations, if you will. Presumably we'll get buy-in. And I told him just put her back to work, right? And then we're going to observe for next 30, 60 days to see if she's moving towards meeting the expectations, the goals, the KPIs, whatever you have it. And if so, great. If not, then we call her in again. Another verbal, and by the way, the first verbal conversation is just verbal. No follow-up in writing, nothing real threatening. Second one, we're going to meet with her again. Say, hey, we met with you, 30 days ago, 60 days ago. We talked about these things. We got your buy-in. And we're sorry to say that we're not moving towards those goals, right? And you continue to not meet our expectations, So we need to bring that to your attention. And then we hash it out again and get through the meeting. But this time, we're going to put it in writing that, not a confrontational tone, just very matter-of-fact, professional follow-up email saying, here's what we talked about. You promised us you're going to work on these goals, KPIs, work on meeting our expectations. And, that's it. We put her back to work again. Because we're treating her with kid gloves because of the potential age discrimination, we're going to bend over backwards. If she continues to falter, then I suggested to them we'll probably have another meeting and write her up a third time before we go to a PIP. A PIP is a performance improvement plan. That's going to be a formal written document that lays out our expectations, how she's not meeting them, what she needs to do to meet our expectations in detail, right? With a deadline now. And we're going to say, look, you need to meet our expectations here, meet these goals, and you need to sustain the behavior, once immediately improve and sustain the behavior. But look, 45 to 60 days from now, if you're not meeting our expectations, it's going to be time for us to be calling it quits, basically, right? And of course, I can help with the written PIP. So I just told them, look, it's going to be a long process. It's not going to be quick here. We need to, kind of just do the setup properly. So that's scenario number one, right? Scenario number two, same idea. Flat rate client calls me. This is a newer one. I reviewed their employee handbook, no charge, excellent looking employee handbook, a security guard company. And basically, they had a progressive discipline policy in the handbook. So this segment of the video is going to be talking about progressive discipline. And for me, in my world, I don't like to see progressive discipline policies in writing in a handbook. Why? And that's the question the client asked me. So I explained to them, well, the only right that supposed right that you have is to terminate employees at will, right? So you can terminate as an employer, so can the employee, for any reason, no reason, with or without cause, with or without notice, at any time. At will employment, right? It's Labor Code Section 2922. But like I tell everybody, and you've heard this on the videos before, at will employment is like Swiss cheese because there's so many exceptions where the law protects the employee. Therefore, we cannot just simply terminate at will, right? We cannot terminate for an unlawful reason. And in the sunny state of California, there's tons of unlawful reasons, right? So I told them, look, there's all these holes in the Swiss cheese already. Why add yet another one known as progressive discipline? Progressive discipline can be seen as overriding your right to at-will employment. And yes, you have a disclaimer in there, and it's common to have a disclaimer right underneath the progressive discipline policy that nothing in this progressive discipline policy overrides our right to terminate you at will. Okay, but really, does that make sense, right? And really, once a jury sees progressive discipline, and even though they see the disclaimer, are they just going to blow the disclaimer off and say, no, you put it in writing, you're going to follow all these steps? By the way, what is progressive discipline? We'll give you follow some steps before we can terminate you, right? It's kind of like a union situation. And you're not a union. These are private employers. So one, we'll give you a written warning. Verbal warning, right? We start off soft and easy. Okay, you don't get it. We're going to give you written warning number one. Okay, you still don't get it. We're going to give you written warning number two. You still don't get it. Okay, maybe we'll give you written warning number three. And then maybe we'll put you on a PIP. And by the way, so you might have recalled just from a few minutes ago, we're implementing a progressive discipline policy for this person that has, us over the barrel for a potential age discrimination case. So what I told this person, the owner of the company, is look, you as the owner and the managers certainly can use progressive discipline, right, in managing employee situations. But you just don't want to have it in writing so that there's any possibility that it could be seen as overriding your right to terminate at will. And actually, the situation that this security guard company was asking me about, they had a new security guard that they use company security guard vehicles, or patrol cars, and the person was a really bad driver. Was evidenced by the dash cam results, slamming on the brakes, almost getting into an accident. There was a live trainer in the car that didn't feel safe with the person. Person's only been there like 3 weeks. And so look, and my client wants to terminate them. I say, look, yeah, absolutely, you can terminate her. I mean, this is us exercising our at-will right. There's nothing unlawful about terminating a security guard with poor driving habits who's driving our automobile. It's a safety hazard, right? No brainer, okay? There's no law that says you can't do that. Although one could argue we got to be careful with sex discrimination because the security guard happened to be female, right? And the female security guards are unrepresented in this particular client's company. But anyway, back to progressive discipline. No, we're not going to apply progressive discipline in terminating this security guard. Okay, so I used that as an example, and it became clear as day to this flat rate client of mine why, we don't want to have a progressive discipline in the handbook. We didn't even follow it here. We just terminated at will. Okay, third scenario, another super classic situation, right? Another flat rate client. I've been on the program for probably about a year and a half or so, and they've been calling me a lot, which is the point, right? They want to avoid stepping in and getting into employee lawsuit. So they have this driver who's been on a workers' compensation leave since, actually not that long, right? They think it's a long time, but in my book, not that long, January 2025. So here it is, October 2025, that's only about 10 months. That's not very long to be on a workers' comp leave for me. And by the way, it's obviously protected, right? Under California law, we cannot terminate an employee that's on workers' comp leave. We need to return them to the same position, assuming the injuries are resolved such that they can perform the essential functions of the job for the position. So, it's a classic situation, right? So the client calls me and says, hey, we're kind of tired of, this person being off on leave, and I keep getting these emails. They asked me about, whether they have to keep the group health, medical health in an earlier email going. And they said they didn't want to. It's been a long time. What do you call it? The annual enrollment period is coming up. They wanted to terminate his insurance. And I told them, sure, under California law, you're not required. Once the person goes on a leave, unless it's a CFRA leave or pregnancy disability leave, in which you are required as an employer to maintain group health medical benefits. For workers' comp leave, you're not. And basically, with the reduction of hours to 0, it's a COBRA qualifying event. So basically, the employer is entitled to send a COBRA notice to this injured worker to let them know that, hey, they need to pick up the premiums if they want to maintain the group health, but employer is going to cut them off essentially, right? But they paid, voluntarily for 10 months. And so now they're cutting them off. So I gave them that advice earlier. So we get a follow-up email, right? Because of course the employee is like going, well, what's going on? I'm getting squeezed out, right? Now my benefits are getting cut off. What about my job? So emails back basically, look, hey, I want to know the company's thoughts or process, once I'm ready to return to work, right? And the employer's telling me this is returning to work is nowhere in sight. The guy has all this medical stuff planned, MRI. He's not, at a point in the workers' comp process where there's any sight that he's going to return to work. And she wanted my help to draft up the response to the employee's question. So of course I helped. I responded basically saying, hey, you know what? Once your workers' compensation case resolves, and or you give us a medical certification to return to work, with or without restrictions, by the way, right? Because you might get a doctor's note returning the injured worker to work with unmodified duty, that it's called, right? Or restrictions. Can't lift over 5 pounds, can't stand for more than 10 minutes at a time, can't walk more than whatever, 30 minutes at a time. That's kind of long. Can't walk more than 5 minutes at a time, let's say. So any kind of modified duties or work restrictions. So that's one way we would return him to work, right? If we got a doctor's note returning him to work with no restrictions right now, then my advice to the client would be we return the person to the same position. Why? Because we're not going to retaliate, if you will, or hold this guy. We're going to return to work because that's our legal obligation to do it. Because if we don't, it looks like it's retaliation or it's a discrimination case for suffering a workers' comp injury, filing a workers' comp claim, being on a workers' comp leave under California law. So we're not going to do that. We just buy ourselves a lawsuit. So the second part of it was, by the way, company has every intent to return you to the same exact position, so long as the medical clearance allows that, right? So like I just said, if after the workers' comp claim resolves, the individual's returned to work with no restrictions, then the no-brainer advice from my perspective is we return the person to work. and we don't retaliate against him. That's his right to have a workers' comp injury, file a workers' comp claim, and it's like it never happened. Okay, you put him back to work. On the other hand, if he never gets released to return to work, or he gets released to return to work with severe restrictions, right, or whatever the restrictions are, we cannot accommodate those restrictions. And this kind of dovetails into disability discrimination law at this point. The same concept, right? We have essential functions of the job that this driver needs to be to perform. And, if they can perform the job without restrictions or without reasonable accommodations is the other way to look at it, then we put them back to work. But if they cannot perform the essential functions of the job, we need to go to step 2 and evaluate the restrictions, modified duty work, or reasonable accommodations is the other way to look at it, to see if there's any of those things that we can provide the worker that will enable them to perform the essential functions of the job. So that's a whole nother process. We call it engaging in the interactive process in the disability discrimination world. But basically, we do the analysis. And if the restrictions are so severe that the person cannot perform the essential functions of the job, then guess what? We don't have to return them to that same exact position. We might have an obligation to find other work if it's available and if they're qualified, right? So let's say this is a driver and the restriction is, cannot apply foot pressure for any extent of time with the right foot, okay? So, well, to me, that's a major restriction that can't allow the person to do their job, right? Essential function of the job: drive, place your right foot on the gas pedal and on the brake, right? And you cannot apply that pressure. Okay, so the next question is, well, is there any reasonable accommodation or can we get around that? I mean, it might be a foot brace, right? So maybe we can get him a foot brace that will allow him to perform the essential functions of the job, so long as he can wear the foot brace and safely still operate the gas and brake pedals, right? But, that's kind of the analysis. That's an extreme example. But, whatever the restrictions are, we need to take a look at them and see if we can live with the restrictions. And if not, what can we do to alleviate the restrictions, right? Reasonable accommodations. All right. With that, that's the day in my life, right? All happened this morning, 3 separate monthly flat rate client calls. This kind of thing that I see day in and day out. Again, these are very classic scenarios. You can apply them to your own business life and probably recognize at least one, if not all of those scenarios. But this is what we do as employment labor lawyers. We're meant to advise you up front. And by the way, call us sooner rather than later. Early is way better, so we can deal with these problems up front. And you see the kind of advice you get. And basically, it's all designed to keep you out of trouble. And if we can't, because in California you have a lot of crazy lawyers on the plaintiff side, employee side, that will sue for nothing, right? They don't need anything. They just sue anyway because they figure they have all the leverage. Then if you get sued, at least we've put you in the best possible position to win. No guarantees. As a lawyer, we cannot guarantee a win, but that's the idea. My advice is intended to put you in the best possible position to avoid the lawsuit, and if it absolutely cannot be avoided, to put you in the best possible position to win. All right, so that's it for today. Aloha.